Good morning. My name is Martin Kenny. I live in the British Virgin Islands. I'm a fraud and asset recovery lawyer, and I represent victims of fraud of all shapes and sizes, including individuals, large groups of people, financial institutions, and sometimes governments in kleptocracy-type cases. In all of these kinds of cases, we have a fundamental problem we face involving risk at the beginning of each case or job. And that is because usually clients who've been victimized or affected by fraud or breach of fiduciary duty or some other form of corruption have either A, had all their money taken from them, so they have no access, natural access to justice, because without money you can't hire professionals like us sensibly to recover value or to conduct an investigation for assets, or they become psychologically disabled. They don't want to throw good money after bad, as a proverbial statement, which is a code for I don't want to embarrass myself further. I'm upset enough by fraud. It's all upsetting. I don't want to go further in terms of risk. What can you do to help me without costing me money is a frequent call from victims. So the only solution that we have is either to raise money through so-called lawyer-financed litigation, the classic contingency fee model, or go to the market to try and raise some money from investors to create a venture between victims and people who have savings who would like to co-invest with victims in terms of the risk associated with the process of recovering assets. So we're going to talk about, today's subject is funding of the pursuit of asset recovery claims and investigations using various different techniques that are available to victims now in the market. We have a very distinguished panel to deliver remarks in this area. First, we have from Canada to my left, your right, Jonathan Cooperman, who's a partner of Farber Financial Group in Toronto. Jonathan specializes in fraud investigations, forensic accounting, and asset recovery, particularly in areas of bankruptcy and insolvency, and large groups of victims and Ponzi scheme type cases. And you'll hear from Jonathan's Canadian insight in this area and the experience he's had to try and organize funding for victims. Then to my right, your left, is Tim Scranton. Tim is a principal of Scranton Dulles International in Washington, D.C. Tim is both an American lawyer and an English barrister. He's also an entrepreneur in the area of litigation funding. Tim having co-founded both Black Robe Capital Partners and Juridica, which is a well-known 6-year-old alternative investment market, London Stock Exchange listed litigation fund. So we'll start with Tim, and Tim's initial mission for 15 minutes with some piping in and the odd interruption from Jonathan and myself will be to lay out the basic principles of the history of litigation funding, the core principles, the framework for analysis, the foundation to the discussion. Tim.
Thank you. Pleasure to be here. So the topic, as you see, is not just litigation funding, third-party funding. We will weave into this topic also discussions of other kinds of contingent fee, conditional fee, damages-based agreement financing. But I think because those are fairly familiar to most, probably the core part of the presentation will focus on outside capital. We'd like to think that when you leave here, you'll have an understanding of how it works, what outside capital is looking for when it entertains investing in some kind of a claim, a case, an asset recovery project. We'll probably start a little general because it's a relatively new world, and go through some of the basic elements with the hope, though, that there will be some valuable takeaway information in terms of whether what you are doing or proposing to do could be attractive to some kind of outside capital. And I think it's useful, too, in that regard to point out that don't think of this just as the litigation funding world, just as the so-called litigation funders who have appeared in the last 6 or 7 years, but rather broader capital markets, whether they're hedge funds, family offices, or other people that could be motivated for some economic reason to become involved in a claim, a case, or a project.
Just as Tim goes on, as a panel we discussed yesterday, we would welcome and entertain questions throughout our discussion rather than making this just us talking to you and waiting to the end for questions. Please feel free to raise your hand. I'm sure there's a remote mic somewhere around, and we can have a dialogue throughout the discussion.
Yeah, absolutely. I mean, it's an intimate group, so feel free, and I'll ask my colleagues to catch the hands if they go up and I don't see them. So, basic place to start, the world that I helped develop in 2006, 2007, late 2007 was when Juridica was launched in London. It's an AIM-listed London Stock Exchange company. It's still traded, but the principal focus was not necessarily to invest in English proceedings. We did several. Some of our great successes were there, but the principal focus was the United States. So a starting point in thinking about this is that law has been quarantined from capital for a long time. Capital is sat, and by capital I mean insurance capital, hedge fund capital, private equity fund capital, bank loan capital, has basically sat on the sidelines and watched law happening. It might be the law of lawyers who go to court. It might be the law of investigators who are part of a project. It might be the work of the forensic accountant trying to unravel a fraud. But all of those law-related things have traditionally been thought of as being outside the boundaries of what capital could rightly come into to do what capital does. And we all know what that is, right? It is to make money. In
a supposedly productive activity.
Correct. I had a remark, and this is not hopefully to disparage the last project that I was listening to in the other room, but I was interested in, as a capital provider and advisor in that area, at the relative cost and benefit of the project that was being described in the Turks and Caicos, and that is that $15 million was spent to recover $22 million plus just over 3 acres of real estate. And I looked at that and I thought, well, they're absolutely laudable goals that were being pursued here in terms of corruption and transparency. Yes? Oh, 3,000. Sorry.
And
saw the wrong digit.
Did he give a value for the 3,000, do you think, Tim?
A lot of it was pretty valuable beachfront. So I'm not sticking up for what you heard through there, but just...
It was 3,000. Okay, I missed my. I thought it was a European point. In any event, what capital looks for is obviously much larger returns than that sort of thing. And what capital looks for are completely commercially motivated cases. That is, cases where there are no lofty goals at issue, transparency, corruption, reformation, or so forth, but rather situations where typical investment style recoveries can be earned.
Although, just to intervene for 1 second, can't capital have a productive day and still do something in the public interest, for instance, in a kleptocracy or corruption case, Tim?
Yeah, absolutely. And in fact, I mean, if you look at motivations, which I'll come on to in just a minute, of how the whole world of litigation funding first developed in the UK through legislation. It was motivated by providing access to justice. That is the principal reason that the entire legislative regime was developed and became law in 2007. So No, and in fact, I will tell you from the perspective of of the funding community generally, it's gone so far as to even have a familiar acronym, which is DVG. My world of capital likes David versus Goliath. Okay, so no, the policy issues, the fairness issues are not lost, and often they are prime motivators, of course, for capital becoming intellectually interested in a case, and then, of course, come the numbers. But eventually, there are the numbers.
I think we intervene just for 1 second. I think you'll find, particularly when I'm going to talk about some of the Canadian perspective, and I'm sure this is true in the U.S. jurisdictions, that access to justice is pervasively discussed in all of the court decisions as to what, in fact, is a good motive, and whether, and we're talking out at a 10,000-foot level on a specific case or at a 100,000-foot level as to what society should be doing, the terms access to justice come out time and time again in terms of the lofty goals.
And just, it's not just the label. Where the rubber meets the road in the structuring of funding agreements, judges get very much involved in their regulation in the English system. They do not want funders to control the case, and they want the natural client to instruct counsel and not get involved in that intimate relationship by polluting it with the less lofty goals of funders. And also, they want to make sure that the funders are good for their money on adverse costs in the English system. We're going to get into all that, but I think there is a merger of interest, is what I'm trying to say, between money that's purely sort of blind, perhaps, to moral issues, and then how judges view the use of capital within access to trials and to the resolution of just resolution of disputes.
Right. I think the the core question, though, is where we sit now in the 21st century. Is it reasonable from a policy standpoint, from a social perspective, to quarantine off the law from capital, or might, on the other hand, capital have something useful to add to the pursuit of law, beyond simply financing the impecunious, the access to justice argument, or providing other opportunities. As I've told audiences before, typically more of lawyers, I know we don't have all lawyers here, that for a long time, the quarantine, in fact, was that the money changers were not allowed in the temple of the law. And you might say, well, why is that? Is that rational, or is it reasonable? And I think the answer really lies in history. It's interesting history, I think. There's some of you that will probably be more fascinated than others by it. But it goes back to sort of the days of Braveheart, Edward Longshanks, Scots painting themselves blue and running around with hatchets, hacking up people. It was in that sort of crucible that the relatively new English monarchy, after the Norman invasion, said, we've got this new court system which is unifying our country, and the good news is that people are coming off the battlefield. The lords are not warring with each other as much as they were. The bad news is they're bringing a lot of their disputes into these courts, and when they do so, sometimes they're bringing them in as stalking horses or in disguise, particularly the phenomenon of a tenant being funded by a certain lord or landowner to bring proceedings against another. And so from that came the notion of maintenance, which is maintaining the lawsuit of another, or champerty, which is a subspecies of maintenance where you are maintaining the lawsuit of another in return for a share of the recoveries. So this was the new age of courtroom battle, where the axes and swords were supposed to be left at the door, but the general principles of battle and fairness of battle and honor of battle made their way to the king, who said, I'm going to prohibit this. Now, that prohibition still exists in many parts of the common law world. It doesn't really exist in the civil law world, but it still exists in the common law world. And we had some conversation about that earlier in Canada.
The Champerty Act of 1897 is still alive and well in Ontario and in Canada, and is used and is still referred to in decisions. And jumping ahead just slightly, while we're going back in history, there have been a substantive number of changes over the last 5 years. And the Champerty Act, as I say, of 1897 in Canada is still on the books and is still regarded as being important. The judges may be interpreting it differently, but it's still there.
Because the temple needs to be guarded. Now, what happened after that? Well, fast forward in 15 seconds, all of a sudden there grew up this profession of people who had previously been basically clerics. They became barristers. They couldn't charge money for what they did. They could only ask for an honorarium. And according to law, you weren't even supposed to give a barrister any money outwardly for the work he did in court, because what he was doing was really for the court and for the king, but you could slip a bit in this little pouch on the back of his robe, and everyone called it good. So the whole idea of being paid for legal services, I mean, goes back to a time that I think we will all agree is completely eclipsed. One bit of that time that's particularly interesting is, at that time, speculation, any kind of speculation, investing in companies, betting on whether a ship is going to go down in the channel or not. Any kind of speculation was thought to be irreligious and illegal. So that's basically where Champerty comes from. We had a different situation, obviously, evolving in the United States. We had a little tea party. We decided that the judge was probably not trustworthy because he had been appointed by a king, and so we'd have a jury, and we left everything to the democratization of juries and took as much as we could away from judges. And we also, in the meantime, said lawyers can be exempt from Champerty, and they can charge contingent fees, and that goes way back, including to Abraham Lincoln's time. So, you know, fast forward, real paradox in what starts to happen in England and the United States sort of over the last 70 years. My favorite little temporal event is that in the same year that England decriminalized Champerty, that is, stopped making it a crime, the state of Mississippi, through its legislature, had a brilliant idea, and that is they were trying to figure out how to, this is in the 60s, they were trying to figure out how to stop this group called the NAACP from supporting and maintaining lawsuits by civil rights violation victims. And they didn't know how to do it. They dredged the old English law, which was thought to be still a root of Mississippi law, which it is, and they resurrected Champerty, dusted it off, and heightened the criminality of it to stop civil rights legislation. So what's going on in England is completely the opposite of what's going on, at least in some U.S. states. So a lot of different kinds of responses to this phenomenon, all of it fairly confused, and all the while the American bar is sitting there a bit like a cat with a canary in its mouth because it could charge contingent fees and no other capital could come into the joint venture project of a litigation. Of course, at that time, contingent fees were improper in England. What is the status now of that, by the way?
Just 2 points, Tim. One, the way I read the evolution from the medieval times to present in the reform of the law of funding claims is tied closely to A, improvements in procedural law of evidence, law of civil procedure, less corrupt circumstances for corrupting the judiciary. I think the 14th and the 13th centuries were rife with corruption in the judicial process in England, but by the 19th century, You had a much more developed legal system, and so the very foundation for why champerty should be present began to be removed, and exceptions began to fall into the law. Very important exceptions. In the 19th century, through mercantilism, you had to move chattel paper around the city of London in order for London to ascend as the world center of commerce. So chattel paper, bills of exchange, promissory notes. In 1885, the English Court of Appeal said, you can trade debt like it was a bale of goods. It was considered a property right. And so debt became, and chattel paper became, a huge exception to the prohibitions against strangers taking interests in something that was called a claim. It was a liquidated claim, so we didn't have much debate about its value, and it seemed pretty certain that someone A owes money to B. So with that greater certainty, the law said, well, the rules for champerty didn't make any sense with a developed legal system and with chattel paper, and we have to move chattel paper around. Another huge area that people don't think about in terms of litigation and funding is insurance. I say that for as long as we've had insurance and men peddling insurance, you've had people shorting the litigation business. They take it short. All we're talking about is on the claimant side is taking it long. The long risk versus the short. What do insurance companies do? They stand by the insured. They fund, they take care of the defense, they actually instruct counsel, unlike claimants whose funders are not permitted in England to instruct counsel. We've had insurance companies instructing counsel, effectively taking charge by contract of a defense for several, well, I guess 2 or 3 centuries. So the exceptions to the rule of champerty began to be developed so much in an area of like insolvency. Liquidators for 150 years have been able to sell claims, with the exception of statutory causes of action like wrongful trading. So there are vast examples in the market where money's been allowed to put bets on litigation in insolvency, in debt trading, and the like for about 150 years. So in the last 10 years, we're really talking about a revolution in the area of funding unliquidated damages claims of uncertain result on liability.
That's right.
I'm going to add on the insurance aspect, and as businesses evolve, and Martin talked about how long-standing the insurance industry has been around and getting involved in various aspects. One aspect that has come into Canada recently in terms of insurance is the dealing with the adverse cost awards. And rather than a funder to deal with the adverse cost awards, which is something I'll talk about later on, one of the new provisions are being brought in, the innovations, is an insurance product which effectively allows for the payment of a premium in exchange for a indemnification on an adverse cost award. An adverse cost award in loser-pay jurisdictions, such as Canada and such as England, I believe, not the United States, where if a claimant makes a suit and is unsuccessful, then, and it could be in large litigation, a large fraud recovery, a large action, millions of dollars in legal fees being spent, and then you lose that, then you are liable for the other side's costs, the loser pay concept. And so the insurance is saying, we'll indemnify, and for a premium, we'll give you $5 million worth of coverage. And if you lose, then we'll pay on the premium, on the insurance, and you won't have to pay the actual premium. But if you win, then we get a recovery along the lines of commissions, and we get the premium that's been allocated. And we'll talk in more detail.
These are called after the event ATE insurance policies, oftentimes where the purchaser of the policy, the claimant, doesn't have to actually pay cash in a premium. The premium can be self-funded against the proceeds of any recovery as a share of the cost value of the case, sometimes 50% of the cost value of the case. So if there's a $5 million ATE policy covering adverse cost risk, then the insurer might charge $2.5 million of any proceeds of recovery as the premium payable only upon recovery. So it's an interesting product where it doesn't cost the client anything in theory, unless he wins the case, and it's only a percentage of the forecasted costs that are at risk in the case.
Right. So you've got all these, I mean, if you're coming back to this historical idea, you've got all these antecedents in history that are developing over sort of 400 years from this notion of champerty. You've got one thing that wasn't really mentioned, insurance subrogation is the one that I like the most. I mean, what is insurance subrogation? It is where an insurance company pays on a loss and takes an assignment of the claim. And they can pursue the claim or not at their own cost and risk, and the assignor, that is the victim, the recipient of the insurance money, the insured, must participate with them. So insurance has been practicing claim transfer, litigation funding, and so forth for many, many years, and it was really that realization, the realization of contingent fees, the realization that these modern doctrines that Martin alluded to, which include prohibitions against bringing frivolous claims and other things that are very familiar across the world, led at least me to look at the world of capital coming into law in '06 and basically say, well, I don't think the emperor has any clothes. And that was sort of the beginning of my own journey in this area. So, I might say that today it's safe to say the quarantine has more or less been lifted.
But when you entered the scene, though, in 2006, Tim, you were assisted by, in England at least, two decisions of the English Court of Appeal, one called Factor Tame in about 2001 or 2, and one called Arkin and Bouchard Shipping Lines about 2005. And in those two decisions that preceded your entry in the market to organized capital, the English Court of Appeal said, one, access to justice is a good, it's a social good. Two, there is no reason anymore or justification for English public policy to shut down access to the court for people who have no access to capital by reason of the champerty principle, as long as their funding arrangements follow certain guidelines. And the guidelines, the core guidelines were two. One, that no funder could control the litigation, could instruct the lawyers on what to do in cases involving unliquidated damages of uncertain question of liability. Whereas, don't forget, in insolvency cases, in insurance subrogation cases, in debt cases, control can shift around. But in this one little area, unliquidated damages of uncertain result and liability, you cannot control the case. Mr. Funder hands off control. Two, if you lose the case, or the client loses the case, you must fund and be able to fund and have the capital reserved to fund adverse costs to the level of the capital that you put at risk in the case. And Arkin was actually in the Court of Appeal. I was involved tangentially in that matter, where Ernst & Young was acted as an expert witness for a claimant. They ran up a bill of £1 million, and it needed to be funded. The funder, MPC Capital, put the $1 million in. All costs were about $5 or $6 million. The claimant was unsuccessful. Adverse costs awarded were about £6 million. And the question that went up to the Court of Appeal was, should the funder on these facts be liable for £6 million, £1 million, or £0? And the result was $1 million. Because the Court of Appeal said we want to encourage responsible litigation funding, and we don't want to chill the market by exacerbating risk for the funder beyond that which they funded on adverse costs. So there was some very specific foundation for your entry in the market in Juridica laid out in England and Wales just preceding your entry.
Yeah. As well as a statute, a piece of legislation, the Courts and Legal Services Act, which was, heavily debated in under the rubric of Tesco law. You may remember that. And it portended the eventual, as I say on the board, legalization of third-party funding in the UK. The U.S. has never passed a statute permitting it. It wouldn't pass a federal one. There's no state, to my knowledge, that's ever passed such a statute. But England, basically, for reasons we discussed a few minutes ago, saw access to justice. I like to refer to it as basically good British government privatization of what used to be a government function, which is funding certain impecunious civil claims with government money, and they turned it out to the private sector within very strict controls. like no intervention in the litigation, no control over the litigation, et cetera. You don't have those statutory permissions in the U.S., but you also don't have those statutory prohibitions in the U.S. So you would find that there are a lot more opportunities to take control in the U.S., and that's probably something we'll discuss more in a few minutes.
So
anyway,
I'm going to say something a little controversial here, Martin, particularly, and that's, while everything you said is mirrored in Canadian decisions, and the judges have said, in fact, that the counsel, in particular in class proceedings, owes its duty to the plaintiffs and not to the funder, and that in fact, the plaintiff must give instructions to counsel and not the funder. On the other hand, they have also allowed that the funder be given a lot of information in order to help it with its own financial reporting and own decision making. And so, for example, one of the cases we looked at was that the funder agreed that it would fund a litigation but not the appeal. If there was an appeal, that funding would not go to that extent. There is, and the judiciary have been somewhat, while they say on one hand that they won't allow the funder to control, they have agreed that the funder is a stakeholder in this. And he who pays the piper calls the tune.
One area of control they do have, Jonathan, is they can stop funding at any time. So if the claimant has misrepresented facts, or the other side comes up with new facts that changes the risk, the funder can abandon the funding.
The other thing that they do is the question of who pays for what, and I'm going to get into it a little later on, but I throw out as something for consideration, in fact, is that as you prepare budgets to decide, in fact, where all of this money is going to go, that the budgetary process and the funder are an integral part of that. And so I hear what you've said, and I hear the decisions of the courts, including in Canada, but I suggest that it's not quite as black as white as let the plaintiff do as what they will.
That's true.
Yeah, agreed. So what you have today, from whatever sources or for whatever reasons or non-reasons, in the majority of the common law world, is a lifted quarantine and a very rich variety of ways that one can finance claim pursuit or claim projects. Even as recently as last year, almost a month ago last year, damages-based agreements, DBAs, are now permitted in England. There's some nuances there that have to be worked out, but you can have something like a U.S.-style contingent fee in England now, which is frankly something I never thought I'd see in my lifetime.
They say they modeled it after the Ontario contingency fee model, which is a little bit different.
Yes.
It's always subject to a review of reasonableness. So if the plaintiff agrees in a commercial case to pay up to 50% of the damages awarded and collected to the lawyers as a contingency fee in England, is always subject to review with hindsight by the judge. Is that fair? Is it reasonable? Is it a rational fee?
Right, but it builds into the menu of options that are now available, which I've basically listed up here. One nuance, for example, of DBAs that hasn't been worked out yet is whether there can be a so-called blended arrangement with a lawyer, where he takes instead of 30% of the case on a no-win, no-fee basis, he takes 50% of his fees paid currently and the other 50% on a pure risk or contingent basis. The law doesn't permit that. There's a lot of talk about, is it even possible to have a blended arrangement there? And I think there's a lot of reluctance to do it, even though certain products are being developed around it. But suffice it to say, pretty open market right now for, for various kinds of claim funding. I don't know who created this entry graphic. So let's cut over to something a little more down to earth, a little more realistic. Who is participating in this market of funding claims, financing claims. And by the way, I'm using the term litigation funding almost deliberately. I tend to refer to a bigger market of alternative litigation finance. It's a term that I came up with years ago and was adopted by the Rand Corporation. They sort of liked it. Litigation funding, to me, and the reason I don't like it so much, is it connotes funding a case, providing the money to someone, an accountant, an investigator, a lawyer, to prosecute a case. Often in this field, you find that what claim holders are doing, they could be major corporations, are not necessarily seeking money to fund a case, but they're rather seeking ways to monetize claim assets or hedge risk inside of a company. A CFO might decide to sell off a portion of his plaintiff's portfolio like he would hedge currency risk, right? There's a risk and a cost in the investment. He wants to hedge it out, and maybe he wants to accomplish something like increase the balance sheet of the general counsel's office so the general counsel has more money to defend those nasty claims, and he gets the money from a short monetization of the plaintiff's claims.
Valuation of this asset called contingent claim rights, it must be a vexing exercise, Tim. Valuation.
Yeah, valuation is, it is tough. It's getting more scientific, and if I can reserve that for a second, come back around to it. But just to give you the landscape, who is doing this? Well, lawyers are doing it. They're doing it more and more. English lawyers are going to start doing it more and more. There is a retail market, perhaps not a very descriptive term, but that is the marketplace for funding personal injury claims, to factor settlements, to make loans against litigation settlements. Basically, the consumer world, which is very different from the commercial claim world, and I think the world that most of you would deal in. The commercial claim finance participants include hedge funds, mutual funds, family offices, foundations, high net worth individuals, venture capital funds. They're all over the place, and I'll come back and touch on that in a few more minutes. Many of them, as I mentioned here, are ad hoc investors. They're not people that are built to take in a regular stream of potential claim investments, but rather they just put the word out that they will do it, if the right claim comes along. They're rather difficult to find, and they span the entire universe of, sort of capital sources, from high net worth individuals to very major firms like Elliott, Macquarie, Fortress, Apollo. All of these groups do this with some regularity. Insurance companies are obvious participants in this world. We tend not to think of them as participants, but of course, insurance companies do finance litigation. And then finally, you see it more in England than you do in the United States right now. There is a whole group of professionals growing up around the intermediary space, brokers, agents, people that you can come to with a claim or a claim prosecution opportunity and have them shop it around.
Because, Tim, packaging the risk, as they say in the business, because litigation is called a risk to people of money, packaging the risk is crucial to give claimants an opportunity to actually get funding and sit down with a funder and have a term sheet drafted leading to due diligence, leading to definitive funding agreements. That is a science into itself. And how to help the client access the cheapest source of funds is also a science. The prices for the capital are all over the place. You could go into the market with one funder and get priced for the client a funding agreement that could be 3 times or 4 times as costly in another source. If you know where to go, who to see, and how to package the risk, particularly, I maintain a portfolio theory of risk. So if you can put a number of cases, client cases, together in a basket of risks, the price drops dramatically for all the clients involved in the portfolio. And I've demonstrated this recently, where 4 years ago, I was able to raise $12 million of capital from a major fund that has $500 million under management just dedicated to litigation funding, and it cost 4 times what it cost recently on 10 cases from Brazil, because we had a decent track record on the first 4 cases, and because when you present 10 risks, it's fairly hard, it's sort of difficult to conceive of losing all 10 risks. And the price just drops and drops and drops, and you'll see it much more competitive price for the clients ultimately if you work hard on packaging the risk and you know the market.
Right, which is, you know, when you think about it, portfolio management. That's why there are mutual funds and hedge funds. It's a way to de-risk through portfolio management. You know, I'm not going to dwell on the U.S. market. It's probably the biggest market, the size of it, but there are other, you know, interesting factors about it. First, I've told people over the years that, of course, U.S. lawyers understood claim transfer a long time ago. They've been doing it for a long time. Through contingent fees, they just didn't like anybody else to really, you know, come in and take part of that market. What we have found is that even contingent fee lawyers, for the most part, are perfectly happy to match with outside capital for various parts of their projects, even if it's only the cost. That is, the experts, the accountants, and so forth. A lot of functional reasons as well. When you're faced with a jury trial in a matter and you would be faced with a judge or bench trial in the UK, the risk analysis becomes quite different. The settlement prospects, statistics say, go up significantly. You've also got something in the U.S. That's a significant benefit. There's been some recent you know, press and case law around this. No loser pays. In England, there is still some fear of engaging in litigation finance, litigation funding, because of adverse costs and the uncertainty sometimes of the insurance that, you know, would protect the capital source from that. I'm going to skip over for a second. I'm not going to really touch on Europe, but I think it'd be very useful for us to look at kind of attitudes right now in, say, the Commonwealth Caribbean, particularly.
There's conditional fee agreements that we were discussing yesterday in the Cayman Islands. The Chief Justice has found that conditional fee agreements can be charged if they are vetted in advance, if the court can assess the proposed quantum of the conditional fee for the lawyers that they propose to charge. The judges in Cayman require the opportunity to review the fee agreement before or at the beginning of the inception of the relationship, where the lawyer is going at risk. We know that we were told yesterday in Cayman, in big liquidation cases, liquidators are going to the judges and getting approved funding arrangements with third-party commercial funders to fund asset-less estates or estates that have deteriorated balance sheets and they need assistance with funding.
Right.
The BVI, we have the same principles, although our commercial court is a little bit more cautious about litigation funding generally, because I believe the commercial court is generally cautious about allowing liquidators to spend money and time on speculative litigation. I think that's the current attitude of our commercial court. So there's a little bit of a difference between Cayman and BVI right now.
That's right. And I think you generally find, you know, sort of the older English view, going back to sort of the factor-tame case in the Commonwealth Caribbean, and that is, you know, it's probably permissible as long as there's no control, no perversion of justice, or anything like that. I commend, I don't have the case site off the top of my head, but about 6 weeks ago, there was a decision in Bermuda. It was very interesting for a lot of different reasons, but the Chief Justice of the Supreme Court said that he thought that litigation funding was good as a matter of public policy. He declined to be affected by any of the appellant's arguments about a company called Harbor Litigation Funding having funded or financed the litigation. And so that was, you know, that was a bit of a surprise to me, primarily because that's where I wanted to base Juridica, but I couldn't get a clear opinion from counsel that it was possible, so I moved it to Guernsey. So you do find different attitudes around. let's look for a second, cutting over more
Just
to...
back, Tim, for 1 second.
please.
The last one you mentioned, Harbor, that they said was appropriate as a method?
Yeah, they said it was.
Interesting, because in Canada, the latest decision was one in July of 2013, and it was the third time that a funding agreement had been approved in a class action proceeding, in fact, and the specific funder, in fact, in Canada was Harbor Fund LP out of England. And just to raise an issue, and I don't think we have to dwell on it, but the whole dynamic of all of these litigation funders coming up and how they are regulated and how their behavior. Harbor, for example, is a member of the Association of Litigation Funders of England and Wales, which is a self-regulatory body which looks after itself to make sure the conduct is appropriate. In addition to that, the entire funding is governed in England by a regulatory agency.
Self-regulation.
Self-regulation. So the concept of these regulators, and there aren't that many around the world still.
It's also a voluntary self-regulation model. It's not statutorily based.
Fair enough. But it's like many of the self-regulating professions, they are trying to effectively increase their citizenship and corporate responsibility to do what is fair and reasonable.
Harbor, for instance, makes it a point they will not fund a risk without making sure that the adverse costs risk, if they're in a fee-shifting environment like Cayman, BVI, England, Canada, is covered. They just will not fund a risk without making sure that adverse costs is dealt with, because they don't want to have judges criticize their model. And I find that some people in New York don't get that and hide behind shell corporations and structures to try and structure a way around or avoiding adverse cost risk, and that's just a recipe for disaster when an English or Anglo-Saxon judge gets a hold of that structure.
Yes, that's true. If you look at you know, why is capital coming into the marketplace? We've touched on some reasons. I put another sort of a digest up on this slide. I would say, if you're interested in this area, if you think it might affect you, keep your mind open to all the possibilities. One that I used the other day with a major law firm I was talking to was, you know, if you went through your files and only picked out those litigation files where some, what I might call fee fatigue, has been expressed to the managing partner. That is, cases where the client has said, gee, this is going longer than I thought, or, you know, we just did this acquisition and we don't have as much free cash flow, or the C-suite cut my budget this year, you know, even though I had the money last year. Any kind of fee fatigue or fee change in attitude, you know, could be a situation where you go to the client and say, you know, have you considered this as an alternative? In England, it's part of the Solicitor's Code of Conduct that you actually have to mention to the client at the beginning of the relationship the opportunity for third-party litigation funding. That's not the case anywhere else, but anyway, think outside the box. You never know when a client might be interested in it. I've actually done trades with companies as big as DuPont who don't need money to litigate their cases, but they see some business reason internally to monetize a claim as an asset, which it is, and pursue it. In terms of, you know, what's driving money into the marketplace, what does the money want? So if you look at the drivers on the supply side, first, these assets are non-correlated, right? They are very arguably, that is, litigation assets, are very arguably recession-proof. I think they're probably counter-cyclical in a lot of ways. Martin and I were discussing yesterday the phenomenon in, you know, a certain third or emerging market that, you know, where the economy is down, litigation is up. And I think you find that in a number of places. So capital is very interested in any kind of alternative asset that's truly non-correlated. And I think it's safe to say, and my belief about this is, except for the phenomenon of settlement, which could be correlated somehow to the markets. An investment in litigation is a fully non-correlated asset. In fact, it may be one of the most purely non-correlated assets that there is.
You mean not linked to the stock market?
Right. Right, disconnected from it. So that's very attractive. The returns are very good. There are some inhibitors. We're still overcoming stigma, mythologies, history.
Tim, just on returns, yesterday we were discussing three leaders in the field. One was Juridica, which you helped us to establish 6 years ago. One is Burford Capital, $500 million under management. Chris Bogart told me about a month and a half ago, who was a co-founder of Burford and the CEO of Burford in New York. And then the third one we discussed was
IMF.
IMF,
Yep,
which is probably the oldest entry in the field. It's a stock exchange traded and has been since its inception in the Australian stock market, or their largest stock exchange, I guess, in Sydney, where they have been involved in litigation funding for about 15 years. They told me they have $80 million of cash on hand to be able to cover risks. They have, I think, a market capitalization in the region of $225 million US. Each of these funds, surprisingly, I mean, I was interested to learn yesterday that, according to Tim's analysis, are producing about an 18% IRR annually on the investments that they've made. So we've got 15 years track record IMF and about 6 years for Burford and Juridica to look at. 18% IRR annually is a very, very good rate of return in any business.
Yeah, if you look at, you may have other views in the audience, if there are any lawyers there that do things on contingent fee basis, you might ask, what is my experience in talking to law firms, and not in the personal injury side, and commercial claim law firms, about their expectations of returns. And many of them have a long history of this, 10 years or more. What is their expectation? Well, generally, if they have one, it is somewhere around a 4 times uplift on the capital they invest, which is typically time, but may also be cash, may also be cost funding. And that investment is coming in over time, right? But essentially a 4 times multiple return over a 3-year average period.
They say 4x in Wall Street, 4x, right?
I was using the, yes, thank you.
4x.
4 times, 4x, yes. So 4x over 3 years. So if the case goes for 2 years, you would expect maybe 3x, right? So in other words, about 100% a year. That's what law firms expect to return, or should expect to return. Most that think about it do expect a return. Now, that is a very, very ham-fisted sort of, analysis, but that's generally what they look for.
So you say 4x, that means in math, so everybody understands it because it's confusing, is if a law firm is forecasting putting in $5 million a time in a job, 4x means I get that $5 million back when we win, the case if we win, plus another 20 million, so that's 25 million. So you say 4x, it's actually 5x in math, but I've never understood my friends in Wall Street why they speak.
Well, but let me, not to debate it now, but I've had the 4x, 5x debate with a lot of people on Wall Street, and there's no consistent understanding of whether 4 means, in Martin's model, whether it's a 15 million on 5 or it's a 20 million on 5.
It's thoroughly confusing to me and to the clients, I can tell you.
So the point is that's generally what law firms are looking for. It's generally what capital is looking for. Law firms have a fairly straightforward way to inject money into a case. They're governed by professional rules of conduct, and they can put in time. They can sometimes put in their cash. Capital is unrestrained. Here are some ways that capital comes in. It might be recourse or non-recourse, meaning
limited recourse.
Or limited recourse loans. That is where the only source of repayment is a case or a basket of cases, as Martin described. It could be a direct purchase of a claim or an interest in a claim. That raises a lot of legal issues for the lawyers out there. Who's the real party in interest? Who might be subject to security for costs? Who might be subject to adverse costs? As to whether you're purchasing an interest in the recovery or part of the claim. In bankruptcy, a lot of times you're talking about purchasing the entire claim or a significant controlling interest in it.
Recently, Chris Bogart of Burford told me that they're developing a new product for law firms, which is full recourse funding to law firms on their contingent claim assets at a much lower interest rate cost than what's otherwise now in the market, where you can go to a hedge fund as a law firm with all of your success fee claims bundled together to get limited recourse funding, but it's quite expensive. It could be 24% interest per annum plus 10% of whatever your success fee revenue might be. But that's a way to, that's an indirect form of funding where the funder is funding a portion of the balance sheet of the law firm as opposed to one client claim or a portfolio of client claims. And these products are all over the place in terms of how dynamic the market is behaving to look at contingent claim rights and success fee rights and securitize them or fund them for the participants.
Lot of dynamic thinking out there. What's going to, I think, enter the market more visibly is the use of insurance, particularly where legal fees are uninsured. Some product as simple as a law firm saying, we're taking this case on a contingent fee basis, and we hope that we recover our $5 million in fees. We certainly hope that we get our 3X or 4X on top of that, but at least our $5 million in fees that we've invested. We don't really like being at risk over that. Can you buy insurance against the recovery of those fees if you lose the case? And the answer is yes. So insurance products coming in, covering capital. I insured a case 4 years ago where I insured not only the invested capital, but also 100% uplift. I was kind of sorry I did because we won the case. We got a 3 times uplift, and I had paid the premium, but I guess I was glad to have it. It was a good learning experience anyway.
Tim and Jonathan, not everybody is a proponent of litigation funding. There are critics. I've read papers coming out of the U.S. Chamber of Commerce which are very vocal against any of this. What is the U.S. Chamber of Commerce? The largest association of businesses in America, big business. And they have repeatedly argued that litigation funding is intrinsically bad because, why? Because it will foment unmeritorious disputes. And all of a sudden, more bad claims will be brought against big American corporations. Do you think that thesis is being shredded by this 18% IRR that the funders are producing?
Not necessarily. Not necessarily.
Well, why would a funder rationally invest in a claim that has no merit?
Well, I don't think they would. I mean, and if they did, it might be an extremely small claim, like a personal injury claim, where they thought maybe there was some nuisance value to be squeezed out of the case. But you just don't see that because, I mean, rational capital is responsible typically to its own investors. And how do you build a business model on the idea of investing in frivolous or small claims where you're going to pursue them only for a nuisance value? It doesn't make sense.
I'm just saying that there is an organized opposition to this whole phenomenon in the United States.
Well, yes, it was organized. I tend to think it's died down significantly. It was led by the U.S. Chamber of Commerce, and it had a certain pretext, and that is that all litigation is bad, first. Second, anybody, and particularly the tort lawyers, so-called tort bar, that pursue mass torts, and particularly in that group, class actions, is probably evil because this is bad for American commerce, and so therefore anybody who would fund litigation is equally evil or bad. The backlash that the Chamber experienced in that was, in fact, many of their large members, major corporations, were very interested in litigation funding for various, off-balance sheet funding purposes, and I think they basically drove the Chamber to quiet down a bit. So, there's some decent policy considerations. But these really raise issues about should there be regulation rather than really should the phenomenon exist.
And I'm going to dismiss the Chamber of Commerce and saying we've already had that argument, we've already had that debate, we've all moved on in life and moved forward. And in addition, the world is changing, and the evolution of even dispute resolution is changing. If you go to the website, for example, of Claims Funding International PLC, an Irish-based company, and you look at what their website says, they talk about dealing with disputes and resolution. They don't even use the word litigation in there per se, because there are other ways of dealing with disputes and moving on. And one of the things I'm going to talk about is, in fact, when you're funding not a specific piece of litigation, but an entire attempt to recover assets. And therefore, you're looking at how you do it on a global basis. And so the actual claims of the opposition, I think, has moved on.
2 minutes, wrapping up.
Do you want
to? Before I invite Jonathan to give a few remarks, I just want to take this back to asset recovery. Litigation funding is a recent phenomenon in areas of unliquidated damages claim of uncertain result and liability. I say that litigation has 3 risks. L for liability, Q for quantum of damages or the measure of loss, and 3, C for collection. What do asset recovery professionals spend their lives doing? We try and solve C for collection risks. If you go to Harbour Litigation Funding, which is a market leader in the UK in this field, as I said before, I think they have a very responsibly run product on adverse costs. Or many of the major headline professional litigation funding vehicles and firms, as soon as you raise the word C or the letter C for collection, they close the door. They say, look, we've told our investors that we're going to take risk on big commercial claims that have merit. They're binary bets in a sense where a judge or a jury will decide on complex questions of fact sometimes or law. In dealing with liability. Does person A owe money to person B? Or alternatively, sometimes we have cases, let's say complex commercial claims in dealing with patent infringement cases or loss of business opportunity profit models. If you run those models, they can be very complicated with many expert witnesses, and you can spend a fortune trying to figure out if person A owes damages to person B, how much? What's the quantum risk? So you've got L for liability, Q for quantum. All of the major litigation funders that have been set up in the last 6 years or so focus on L and Q risks, and virtually none look at C for collection risks. And I think that it's a complicated explanation for why I believe that is the case. It's just the reality. So what do asset recovery professionals have to do if the door is being shut on us because we present so-called collection risk? And our apprehension of our work is when someone breaches a fiduciary duty, when someone loots a bank or a country or runs a Ponzi scheme, L for liability is not really a risk. It's objectively ascertainable that someone has stolen money from someone else. The measure of value of the loss, the quantum, is usually not debatable. It's based on objective accounting records, payment records, wire transfer details. We know how much was stolen. So we don't present L or Q risks, we present C risks. Now I make the argument to funders, wait a minute, you like the portfolio theory of risks, why are you working in space L and Q and nothing in C? And slowly we're making inroads to get them to buy into taking risks in our area of asset recovery. And I say each of our big cases represents a suite of risks. Imagine you go into a case like Madoff or Stanford. In Stanford, there was $10 billion come in, $5 billion go out to the folks, $5 billion core capital loss. $500 million of assets were recoverable, $300 million of cash, $200 million of land. And about $4.5 billion was a big hole in the balance sheet. You run into that case. We had a conflict. I'm working on the case for the Antiguan liquidators, and some folks called Baker Botts in Dallas act for Ralph Janvey. And we had a war for a couple of years over the $500 million. We settled the war, and we split the money basically in half. And we're using some of those resources to fund major tort claims. So we present a suite of risks in terms of a boat, some land, a bank deposit. Each of those are discrete risks. To attribute through evidence attribution evidence of the assets, the hard assets, to the wrongdoer or the wrongdoing. That's our business. We're collectors of attribution evidence of assets to the wrongdoing or the wrongdoers. And I present these risks to funders and say, look, we have a portfolio of just hard asset risks, and when we're doing our tracing work, we identify law firms, bankers, accountants to sue for dishonest assistance, recklessness, sometimes negligence. And those are some good cases with deep-pocketed defendants. Now we go back to L and Q risks, right? So we have a big L risk in bringing a ancillary civil liability case against a bank. I'm chief counsel in charge of a case with Link Kaler at Bennett Jones in Toronto suing TD Bank of the Stanford case for $5.5 billion of damages. That grew out of interviewing 52 witnesses and working the case hard to develop a good tort case. So we present initially C risks for collection, then we metamorphosize ourselves into big L and Q risks, usually L risks for liability. And it's a fascinating subject to take into the houses of money and explain what asset recovery professionals do, because they don't even think about what we do, and we need to communicate better to get the costs of the funds down for the clients and access to more cases for ourselves and the clients. Now over to Jonathan to talk about his perspective, in the Canadian perspective in this area of access to money for folks victimized by fraud in Ontario in particular.
Can I have the clicker?
We have not too much time, maybe 7 or 8 minutes.
So Tim and Martin have left me 4 minutes left, and I'm going to give the, as I listen to lawyers debate about the mathematical concept of 4 times X. What my perspective is not just a Canadian one, but as the accountant on the panel and as the recovery professional, I'm going to actually bring the discussion down from the high level to some practical issues at dealing with a litigation fund agreement. And those in the audience who actually do litigation recovery of assets on a fraud, there may be some practical applications. So I'm going to try to get through it fairly quickly. That's just my bio that, in fact, brings in the perspective of being the accountant, the insolvency professional that deals with the actual recovery. So let's say we have, in fact, a Ponzi scheme, a $100 million Ponzi scheme. I had a case. A dentist said he developed a tooth whitening product. He effectively sold shares with the promised recovery of $20 for every dollar invested. They would get their money in 6 months, and $100 million later, we actually traced $78 million. There was a Ponzi scheme fraud. So, but you don't get the funding, and you don't need the funding, and you're not capable of having it from the get-go. You have the information, you know about the fraud, you retained, you have some initial investigations, there are some perhaps preliminary proceedings, usually a statement of claim is filed, the appointment of a receiver. And where does the money come from? Well, as Martin said, the victims have lost their money or don't want to admit to it. In one particular case, we convinced, in a small Ponzi scheme, we convinced 70 victims to each put in $1,000. We got $70,000 to get it going. In many cases, they've lost their life savings. The professionals often effectively fund the initial investigation, and you look to easily recovered assets. You look to luxury automobiles. Fraudsters are pretty predictable. In this particular case I'm talking about, we had a condo on the waterfront, we had 9 luxury automobiles, we had a strip mall. You realize on those as part of the funding. But then what? You realize in my case we had $54 million that went to a sports book in Costa Rica. We had $18 million went to a sports book in Jamaica. You identify other pieces of litigation and you recover the easy, low-hanging fruit, but where do you go from there? You're going to need more investigations. You're going to have to start actions, and you're going to have to need and pay for other investigators, which don't go on a contingency basis, forensic accountants, technology, digital experts. All of these people and all of these other disbursements have to be paid for in some way, and then you start at that point in time sitting back and recognizing, where do we go for the money? Okay, you've got the professionals, in our case a court-appointed receiver. You have legal counsel which may agree to act on a contingency basis. In our case, we had our Canadian counsel which did not. We had our California counsel which was on contingent, and we had our Swiss counsel, and contingent fees weren't allowed in Switzerland. And we have all those disbursements that I was talking about. So you've got to start to deal with that. Now here, it's not one particular piece. I'm going to go back to what Martin said. One particular piece of litigation. It's the umbrella. In fact, you may have 6 different pieces of litigation as part of what you're trying to do as the recovery professional to get the money back for the victims.
The trustee in bankruptcy of Rothstein told me, his counsel told me last night, Chuck, that they had to file 200 lawsuits within the first 2 months of entering office. 200 lawsuits. It was a mad rush to build claims.
Okay, so let's start now some practical. You're dealing with the litigation funder. And you don't get an agreement at the very beginning. In fact, you enter into an agreement, a written agreement with the litigation funder, and usually there are 2 in my experience. We've done this. What you have is a retention agreement, and the retention agreement is actually between counsel and the litigation funder. The litigation funder is providing financial advisory services, and one of the reasons for that is to protect the privilege of all the information documents he's going to need. One of the things you have to be very conscious of is the protection of privilege.
Jonathan, is there any case law yet in Ontario dealing with defendants trying to pierce privilege by saying, well, the funder isn't a party and they're not under the circle of privilege. We want all communications with the funder.
Well, and the answer is yes. Recent case law has said in class proceedings that although the litigation agreement itself is not a privileged document, that they expect the funder to treat confidentially. And although the cases actually don't talk about privilege per se, they allude to it in enough ways that I would expect privilege would be protected. I had in one particular case where our funder, in fact, was examined under oath, and we said he was protected by privilege. Yeah, go ahead.
I would say that there can be no more sensitive documents in a case in asset recovery or litigation than funding proposals, because you're telling everything about the case. You have to tell the prospective funders all about the risk, the good parts and the bad parts, and the strategy and the budget. And if the defendant gets a hold of these papers, it's devastating. It's like having no privilege left. Now, in the United States, I remember the U.S. District Court in Delaware said that when one party was going around New York and handing out confidential under non-disclosure agreements, the funding papers to a number of prospective funders, the U.S. District Court judge found that there was privilege still attached to all of those communications because of the existence of the NDAs and because of the sensitivity of the information. Whereas I think there was another U.S. court that found a different conclusion, I think in Florida, that pierced the privilege. So I think you have conflicting case law in the United States on this crucial question.
Yeah.
We were able to, in Canada, in one case that I had, we actually had our litigation fund agreement under seal. The court allowed it to be sealed. Now, more recent cases in class proceedings have said, in fact, that they will not entertain that. Early decisions, in fact, there were 2 decisions, one out of Alberta and another one out of Nova Scotia, that did allow, on one case it said it was a motion ex parte, and in Canada ex parte means without notice entirely, not just an expedited notice. There's sometimes a difference in that term being used.
Completely secret.
Completely secret, and the order simply said the funding agreement is approved and the document is going to be sealed. There was another one in Nova Scotia that also had the same result, although what they did is they had certain provisions that were in the order redacted in order to not disclose what the funding agreements were. In our particular case, we had it done under seal, and our court order actually said that, in our case now it was a private lender, for the purposes of privilege, the funder would be considered as an agent of the receiver. And specifically, all privilege would apply.
Just skipping to Gustavo Sawyer, my client, in 2 cases, one called Boi Gordo, the other is in secret case in Sao Paulo, Brazil. I think our fee agreements are in the judicial secrecy file in the bankruptcy court in Sao Paulo in both cases. Am I right, Gustavo?
Yeah, you're correct.
But in one case, we worked on a different one called Petrofort. I think the other side attacked our fee agreement as being unlawful, and the TJSP, the Court of Appeal, upheld it.
So the only other point on this slide before I move on is there's usually a work fee provided to the litigation funder for the due diligence. And when we talk in a minute about all of the monies that must be available, it's not as simple as a matter of this is a commission that's going to be paid to the litigation funder. It starts off right at the very beginning. In this case, the work fee for their due diligence is usually an amount payable. So, in fact, let's look at the litigation funding agreement and what are the kind of general terms that are outlined. We've talked before, and I'm not going to repeat all the discussions about maintenance and champerty, and I'd be happy to give you case citations about what the courts would deal with in class proceedings. But the litigation funding agreement must talk about what's going to be paid for and what's not. Are the lawyers, in fact, on a contingent basis or an hourly basis? Or is there a blended? Usually the courts, in fact, in one of the recent cases, the judge said she wanted to see people have skin in the game. Who are the stakeholders? That also applies, by the way, to the plaintiffs. In one particular case, there was an obligation on the plaintiff to promptly deal with advice to counsel because they no longer had skin in the game except for recovery of their loss. What legal proceedings are being pursued? We talked about the appeals, adverse cost awards. Arrangements to advance monies. What are the arrangements going to be? How is that money from the funder going to be given out? Security for costs, bonds. I had a situation in Panama. We had a $1 million condo that we expected was going to be in Panama, but to get even a freezing order for that, we would have to issue a bond. It's a matter of prioritizing, and this is one of the things that comes in dealing with litigation funding. And when I said before, he who pays the piper calls the tune, and while the courts say that the litigation funder, in fact, can't control it, on one hand, you must prioritize these monies that are going to be available. And if you have assets and you had all the money in the world to try to recover them and litigate, you'd go after everything. But you might actually have to give up on pursuing certain assets because there are budgets to be prepared and followed.
What about settlement policy? Do you ever see it in Canadian funding agreements where in advance the funder and the funded agree a settlement policy? Or to me it's a vexing issue because the funder is not supposed to control, and yet the funder is very interested in what is the policy about settlement?
Well, 2 years ago where there was a case, and in the initial funding agreement, in fact, said that the litigation funder could attend settlement discussions. The judge did not accept that and made a condition of approving the funding agreement to remove that. I've had a situation where we have had a litigation funder who brought a specific expertise, and we included him in settlement discussions, and that was approved by the court. And I'm going to go back to something that I said before, and actually Tim raised, is what is the nature of litigation funding? Is it like a private equity? Sometimes the litigation funder, who is not a large institutional hedge fund, brings a specific expertise to the table, and litigation isn't the end result. Recovery is the end result.
I think one of the good things they bring is rigor, financial rigor to the process. Make sure the budgets are being kept by the lawyers, and they watch everything like a hawk.
So the role and involvement of the funder must be outlined, and the court will look at it. Cap on funding, I'll quickly, later on I'll talk about how some of that is looked at and how accounts are looked at. What is the compensation? Well, the compensation isn't just a percentage. There is often a signing agreement or a commitment fee that's given to the litigation funder to enter into the agreement. There's a work fee.
What about conflicts of interest in the way the funding agreement is structured in money terms? Many funders in New York in particular like to charge, as Tim was mentioning, well, 3x or 4x or whatever it is, x. That means if they put in $1 million of capital, they're expecting to get back, usually, from the ones I deal with, their goal is to achieve that $1 million back plus another $3 million. So every $1 million you burn in the case, they get $4 million back. So if it's a big case and you need $5 million of funding, they get that 5 back, plus another 15 million, or the first 20 million. And they seem to always, from New York, ask for the first 20 million. And I argue that creates a huge conflict, because already the funding agreement intrinsically creates huge tension between the funded and the funder. The funder doesn't care if a penny more than 20 million is recovered. Well, the funded only cares about that which is recovered over $20 million with that structure. So I argue this is insane. You're going to create fights as we go along. Even though you're supposed to sit in a box and not control anything or say anything, you're going to use your power to stop funding as a threat to extort some kind of settlement that is not in the best interest of the client. And it's not good for you to be put in that position, because it's a moral hazard for you, and it puts the client in a bad position. So I always argue that, okay, get your capital back and maybe some interest rate, 10%, 12%, they asked for 24%, some interest rate, and then at net proceeds we split. Funder maybe take 30%, if it takes 18 months, maybe a bit more, 35% if it takes two years, maybe a bit more if it takes 3 or 4 years, maybe 40%, sliding the scale up for the duration of time. Why? Because funders are concerned not just the quantum of capital they get back and profit, but when they get it back, because they're always focused on IRR, which is time value of money. So if you focus on building a structure where interests are commercially aligned, it's a much better structure for the long run, it's more sustainable, and you end up, hopefully, if you win a case, without a big war going on internally about settlement policy and how to, what is success? The funder may be happy, but if the client doesn't get anything, that's not good for the funder in the long term. They're supposed to be helping folks get to court and recover something and not take all of the result of the case.
The success fee that I've put up on the slide there, you'll see the percentage of recoveries is not the entirety of the substantive recoveries that often occurs. In many cases, there's actually a multiplier of the monies advanced, and that actually goes to trying to make the sides align, their interests align, so that the funder is compensated when he actually has to put out money. But if he doesn't have to put out money and it's not required, then his compensation would be less.
I think we're going to have to bring this discussion to a conclusion because lunch is starting now. But are there any questions for members of the audience? No? Oh, sorry. Dennis, you have one?
How do you deal with the duty of loyalty to which client do you owe the duty of loyalty to?
That's a good question, and the English cases are clear to the client, to the traditional client, the claimant. And as I tried to outline, the English cases are also clear that the funder is supposed to be at arm's length and not instruct counsel at all. So they're supposed to keep their hands off of control, and what we're debating is what does that actually mean in practical terms, that the funder can stop funding if they don't like the risk halfway down the journey. It's a vexing issue, and it can present big problems for counsel unless you make it very clear at the beginning in the agreements, I get my instructions from the natural client, not from the hedge fund.
My answer to that is it depends. It depends. I mean, I've done deals before where you have a tripartite attorney-client relationship. The claim holder, the law firm, and the funding source, okay? It's perfectly permissible in many places as long as you can deal with the conflicts, right? So you might have a dual duty of loyalty. And this is not so foreign when you think about, closely held company. You've got two shareholders. They're, one of them's funding the litigation. The other shareholder is interested in the litigation, obviously, if it wins. I mean, dealing with, working through those kinds of conflicts is really no different. So you can structure things in a number of different ways. You've got more prohibitions in England than you do in most U.S. states. So
on this subject, yes, the conflicts is a big deal in England. Yes. Sid? Okay, well, thank you for attending and your attention. Thank you very much.